What should I do when I receive a notice of intent to deny? I believe actually March 23rd, USCIS already made an announcement back in January that March 23rd, 2023, they are not going to allow any more COVID flexibility rule. If you received a notice of intent to deny or RFE or anything similar to that, you probably have a good idea what I'm talking about. It's going to be based on the deadline in the notice, okay? So no more 60 days extra. Get it together. Don't wait around. Okay. USCS has been very flexible in a sense. Maybe not for you. I'm sorry. They've been very flexible because of the COVID pandemic and everyone's living life like there's no COVID anymore. I agree with them that they don't need to have this extension deadline or extended 60 days. I think it was great. I think what had happened to some people is because they depended on it so much, maybe even lawyers, I'm not sure, but they could have missed a deadline. They could have missed the response deadline. So what we do as a team, okay, we set it 1 week before, we set it 2 weeks before. So, and we have a client call, a client meeting. So for example, I just had one today. Fortunately, in this situation, the client was proactive. They got notification before we did, which typically is the case. So don't give your attorneys a hard time if you receive the notice of intent to deny or RFE maybe before your attorney, because that's typically the case. And especially if you have access to USCIS online account, then you would have access to that first. Okay, so because us attorneys don't have access to your account, you would have to share those credentials to us. You might be wondering, well, I don't understand why this my other friends or people I know, they just went straight through. They even got interview waived. And you're like, you talk to them about like, hey, what evidence did you provide? And you try to compare. I don't think people really go into that detail. Maybe I'm wrong, but you try to compare with them and you come to find out you're like, well, it sounds like I gave more evidence than you did. And you got approved with or without interview, but they didn't get the NOID or they didn't get an RFE. USCIS, number one, is not perfect. And I do believe that to some extent that USCIS does, I don't know if you want to call it play favorites with certain countries of nationality. That might be a better phrase than say like discriminatory, but let's just wanted to put it out there. I see a pattern with these situations because we have plenty of clients where, maybe they, just got married. So they just joined each other's bank account or one bank account. And that's all that matters. They care, USCIS cares about financial documentation in terms of you have it joint together, but they're not going to ask for every single bank account to be joined together, which most of our clients are a little concerned about doing that anyway. So by the time you just got married, you just got an account shared together, you probably might not even have one statement together. I always recommend at least waiting until one statement comes through the cycle. But we have our max plan is file your case in 30 days. Of course, you have to be married in this situation. But if you don't have a statement cycle already came through, then the bank would usually give you some kind of one pager that would say, okay, so and so joined your account or vice versa, right? I'm sharing this because you might be receiving this and confused, right? You're seeing the news. We just sent an email out to everyone saying we just had a success story. We have success stories all the time. Fortunately, knock on wood, with a wonderful team. But there are situations where USCIS won't do it, review your case or analyze your case apples to apples, okay? In the same way that they look at someone else's case. I don't know why. That's unfortunately true. I've just seen the pattern, even though we provided everything that the other cases have been approved without a waiver. Okay, so try not to freak out because it does, when you receive this letter from USCIS, whether it's on your online USCIS account or in the mail, okay, it does have that word deny in there, but before that word deny, it has notice of intent to deny. The government's trying to say, look, based on the evidence you provided, it's not enough. So we're giving you this one last chance to provide us evidence to overcome our intent. And so it's actually nice in a way that they're giving us this chance, right? Giving you this chance. So it's very important that you understand this. No one likes to receive something like this because people think, number one, they think they're denied already, despite it's the language in the notice is a little bit confusing. If you've never had to read one of these before, we have experience, so we understand what to expect. One of the things you need to know about these kind of cases, first of all, is that the standard of evidence. This is what we learn in law school. Like, what is a level? How basically like how convincing does the evidence need to be? Okay, in general, we call evidence bona fides. Okay, so if your own lawyer, you talk to someone and says they use the word bona fide, you could be like, what the heck is that? This basically means legit documents. Okay, legit evidence. Okay, let's see if I can find this on the USCIS website so you can feel hopefully better about it. Okay. So you can see I'm on the uscis.gov website. I love using government websites, not even my own website, to be honest, even though we do try to update it as almost every day with information. But it's, and the reason I say that, you have to look at USCIS website, especially if you're filing on your own or you have your own case that you already filed. So here it is, burden of proof, okay? Burden of proof. So here it shows that the burden of proof, like who has the burden? That is to you as the applicant or to attorneys, right? I don't like to say attorneys because really we're asking you for the evidence anyway. But of course, it's our job to help you organize it, to make sure like this matters, this doesn't matter, that's not applicable, or this is very helpful. Look, everything you just gave us is not helpful. That happens from time to time. So that's one reason to hire a lawyer. Let's see here. So that's the first thing. The second thing, what is a standard of proof? The standard of proof applied in most administrative immigration proceedings, meaning like USCIS, is the preponderance of evidence standard. It says, therefore, even if there's some doubt, not doubt that it's a legitimate document. And of course, number one, it has to be legitimate. It cannot be fake, obviously. But even if there's a little bit doubt, some kind of doubt, it doesn't say how much, and say 50% or more. It says, if the benefit requester, so it could be meaning an applicant, foreign national, or sponsor, petitioner, if the benefit requester submits relevant, credible evidence, credible meaning the truth, okay, not a falsified document, so a credible evidence that leads an officer to believe that the claim is probably true, they use this in quotations, probably true and more likely than not, then the benefit requester has satisfied the standard of proof. So what that means is, if you have all this evidence, it shows that you have a life together as a married couple, for example. We argue, of course, every time to USCIS that this satisfies the preponderance of evidence standard. That's very important. So if how it relates to other scenarios like a criminal law case, not immigration court, but criminal law case, that's what we call beyond a reasonable doubt. So you have to remove every single doubt that that person is, innocent. Because if there's any percentage of that person being possibly innocent, then that person's not guilty. So in this situation, it's different. This is a civil situation for immigration. This is a preponderance of the evidence standard. So if you receive one of these and you're like, man, I really did give everything to USCIS. Well, look, it's probably been several months now. You can provide updated evidence like the shared bank statement, bills, statements in general, credit card bills. I always think like checking or credit card bills are one of the best, because if you use those accounts for, it was a debit card or whatnot, or a credit card, then, it could show all the activity right there. It's the best. So you don't necessarily have to give every single month of a utility bill. You could, but, up to you if you want to print everything. But hey, if you receive a notice of intent to deny, it doesn't hurt to provide all this, right? But, usually when we file a case at the beginning, we don't give every single month statement in terms of like utility bills, because there's so many, right? You got the cable, or potentially so many cable, cell phone, shoot, there's like so many subscription things these days, like Netflix. So whatever, there's so many, light bill, gas bill, maybe tuition, I'm not sure, but there's so many potential expenses there that it might be just better, put it on a credit card or your checking account to expense it. That'd be easier for the officer. So, and by the way, especially if you moved addresses and you want to get a new updated driver license, okay? And so typically by the time you receive this notice of intent to deny, you likely, not everyone's in a situation, you likely would, USCIS already approved your EAD, your work permit, and advanced parole. So you need your EAD, if you overstayed your visa, then you need your EAD to take it to your respective states Department of Motor Vehicle or Department of Public Safety to get a driver's license, right? So I always have to share a lot of caveats, a lot of disclaimers. Because some of y'all, if you don't have the work permit, you go to DMV, you're like, well, John told me to do this. Well, you have to have the EAD, the work permit. Every state could be slightly different. So you need to get updated address, because I've heard of stories, fortunately not our clients, but heard stories where they go to if USCIS does require an interview and you go there and they're like, hey, well, show me your credit cards together, which really doesn't make sense because the credit card numbers are different, but at least a driver's license, because that would need to show the updated address. Now, look, I get it if you don't have time, but if the old address is the same as both spouses, right, then I think that's understandable. But hey, on these, you can apply online, or you can at least start the process online, I believe, to renew or update your driver's license. So why not try? Check it out. There's really no excuses to not get it done, okay? Unless you're like interviews tomorrow. So it's a different situation. All right, y'all have a wonderful day.